This is Barry Zalma on insurance. I'm an attorney who has retired from the practice of law and now spend my time as an insurance claims consultant and expert witness, an author and producer of these videos. Today I'd like to talk about warranties in insurance policies, which are nothing like the warranty on your garbage disposal or refrigerator. Certain policies contain the term warranty. This in insurance is a word of great power. Generally, a warranty can be defined as, quote, a warranty in insurance law is a statement or condition forming a part of a contract whereby insured agrees that certain acts have been or shall be done, and validity of the contract depends on the exact fulfillment of the condition, regardless of whether the breach relates to or causes the loss sustained. A warranty in an insurance policy is a special kind of representation where the person seeking insurance promises that the statements of fact are absolutely true, that they know that the insurer is relying on the truthfulness of the statements, and that each statement of fact is material to the decision of the insurer to insure or not insure. Warranty has also been described as follows. The term warranty frequently has the connotation of an affirmation or a promise. However, functionally, the significance of a warranty in an insurance policy has been and continues to be that it establishes a condition precedent to an insurer's obligation to pay. When an application for insurance is attached to the policy and made a part of it, the statements of fact in the application are converted from mere representations to warranties. By accepting the policy with the application attached, the insured acknowledges that it has warranted, promised to the insurer that each statement of fact in the application is absolutely true and that the policy will be void if the statements are not true. An insurance company has the right to extract from an insured a warranty of any factual matter it considers material and may reasonably provide for voidance of the contract if such warranties prove false. To do so, however, it must be stated clearly and unambiguously on the face of the policy. Failure to comply with a warranty can convert a clearly covered and compensable claim into one that must be rejected. It is therefore imperative that every adjuster and every insurance lawyer understand what a warranty is and how it affects the investigation and adjustment of a claim. New York's insurance law defines a warranty as, quote, any provision of an insurance contract which has the effect of requiring, as a condition precedent of the taking effect of such contract, or as a condition precedent of the insurer's liability thereunder, the existence of a fact which tends to diminish, or the non-existence of a fact which tends to increase the risk of the occurrence of any loss, damage, or injury within the coverage of the contract. This is a decision of Kephart versus certain underwriters at Lloyd's, a Southern District of New York decision of 2019, quoting New York Insurance Law Section 31 06, paren A, close paren. In certain underwriters at Lloyd's versus Jimenez, a district court of appeal from Florida's 3rd District in 2016, found that those certain underwriters at Lloyd's appealed a final judgment following a non-jury trial in which the trial court granted declaratory relief to Raul and Ada Jimenez, the appellee's homeowners, and determined that Lloyd's was not entitled to rescission of the property insurance policy issued to the homeowners. In 2007, Raul Jimenez, on behalf of himself and his wife Ada Jimenez, completed and executed an application for homeowners insurance on their home built in 1985, with assistance from their insurance agent A&A Insurance Underwriters. A&A submitted the Jimenez's homeowners insurance application to a managing general agent of Lloyd's. During the application process, A&A asked whether Mr. Jimenez had a smoke, temperature, or burglar alarm, and if so, whether these alarms were monitored. Mr. Jimenez said he had a monitored central station alarm on the property. On the application form, Mr. Jimenez designated the central station monitor as a protection device that monitored for smoke, temperature, and burglary. After signing the application, Mr. Jimenez was given a copy and was given a chance to ask questions and make sure his answers were true and correct. The policy was given a discount because of the representation that the Jimenezes had a central station alarm monitoring for smoke, temperature, and burglary. The policy was renewed 3 times with the same representation and warranty about the alarm system. In August 2009, there was a kitchen fire at the Jimenez's home. Delta Alarm Systems monitored and maintained the Jimenez alarm system. At trial, Jose Quintero, the corporate representative of Delta Alarm Systems, testified that the Jimenezes had a burglar alarm, but not a central station monitor smoke or temperature alarm system. Lloyd's expert testified why the alarm warranty was material. New York law has long provided that the breach of an express warranty in a marine insurance policy, whether material to the risk or not, whether a loss happens through the breach or not, absolutely determines the policy, and the insured forfeits his rights under it. As New York's Court of Appeals has explained, an express warranty in a marine insurance policy must be literally complied with, and that non-compliance forbids recovery regardless of whether the omission had a causal relation to the loss. An insurance company has the right to rely on an applicant's representations in an application for insurance and is under no duty to inquire further unless it has actual or constructive knowledge that such representations are incorrect or untrue. Under Florida law, an insurer has the right to unilaterally rescind an insurance policy on the basis of misrepresentation in the application for insurance. The misrepresentation need not be fraudulently or knowingly made, but need only affect the insurer's risk or be a fact which, if known, would have caused the insurer not to issue the policy or not to issue it in so large an amount. The misrepresentation made by the Jimenezes regarding the presence of a central station monitored system on the property in the insurance application precluded coverage because the misrepresentation was material and was detrimentally relied upon by Lloyd's. It issued a discount because of its existence. Because the appellate court found that there was a material misrepresentation sufficient to allow rescission, The case was remanded to the trial court with instructions to enter a final judgment in Lloyd's favor because the policy does not provide coverage for the Jimenez's kitchen fire under the language of the protection device endorsement, and because Lloyd's is entitled to rescission of the policy due to material misrepresentations in the application, which material misrepresentations were also warranties because they were attached to and formed a part of the policy. It is not only a violation of the covenant of good faith and fair dealing to lie on an insurance application. In some states, it's criminal to lie on an application. Rescission, on the other hand, is an equitable remedy where the court determines, because Lloyd's in this case was deceived, it did not matter that the insured intended or did not intend to deceive it. The policy was void from its inception and by law never existed. When a policy contains an open pilot warranty provision that the policy will not apply while a scheduled aircraft is in flight unless both the pilot in command and the second in command have completed the manufacturer's recommended ground and flight training school for the applicable make and model aircraft within the 12 months preceding the date of flight, it must be enforced. In Lima Delta Company versus Glob R1, a Georgia case from 2016, it was undisputed that one of the pilots on the February 12, 2012 flight had not completed the required training within the 12 months preceding the date of the flight, and therefore there was no coverage. California has adopted the Marine rule, which is that a breach of warranty, whether intentional or innocent, allows the insurer to declare the policy void. Normally in marine and inland marine policies, warranties are strictly enforced, and breach voids the policy regardless of materiality. Some states, on the other hand, require that the breach be causally related to the loss. Some require the warranty to be material. In Missouri, for example, statutes provide that in policies for insurance against loss by fire, tornado, or cyclone, warranties not material to the risk insured against are held to be representations only. Warranties are always, however, a promise. A warranty is not the same as an exclusion because an exclusion does not involve the insured making a promise. A warranty, whether express or implied, stands in contrast to an exclusion, which does not represent a promise on the part of the insured. Maritime warranties generally have to be strictly complied with in order to recover under the laws of most jurisdictions. This video was adapted from my book, Zelma on Insurance Claims, Part 102, Second Edition, and is available as both a Kindle book and a paperback from Amazon.com, along with 9 other volumes of Zelma on Insurance Claims. The second volume explains, in addition to what we've discussed today, the types of warranties and how they are dealt with by the courts. If you found this video to be of use to you or of interest to you, please refer it to your colleagues. It's free. And please subscribe to my YouTube channel, my Rumble channel, and my blog so that you can learn about future blog posts and videos. Thank you again for your attention.